All right, is the court reporter and the clerk ready to go?
Ready, Judge.
Okay, let me call the case and I'll take the appearances of the attorneys, and the parties. The court calls 2020 FLA 1326 D4 in the matter of Carlos Alanis and Carla Carrillo Alanis.
Your Honor, I'm sorry, Hector R. Garza Jr. for the respondent, Marla Alanis.
Good afternoon, Judge. Adriana Maddox, present for Carlos Manuel Alanis. He is also present.
Good afternoon to everyone. We've got quite a bit to cover today, this afternoon. This is really the only case I have this afternoon, so we're going to try to hammer out as much as we can. There will be a slight deviation at 3 o'clock. I have to attend to bond reduction hearings. They're informal, so they won't take very long, about 10 or 15 minutes, so you all can anticipate a break at that time while they take care of the bond reductions. Again, they usually don't take more than 10 or 15 minutes.
Mr. Garza and I conferred on the discovery, and we have, so it shouldn't take us, hopefully we'll be done by 3.
And I was about to say, Judge, if I may, if I could propose, I think we could probably move through this pretty briskly.
I was going to
If we
suggest
handled,
do that, and I took the time actually to go through all the requests you have in your motion to compel, and I have some notes, so it's going to go fairly quick.
right,
So how do you want it? This is your motion, so, Mr. Garza. So
okay, if I could, Judge, first and foremost, Ms. Maddox, the order appointing Joe Maldonado, I had emailed you that January 18th. You and I were supposed to talk about it, and I completely forgot about it when we last spoke on the discovery. I'm not sure if you've had a chance to go over that. Do you have a position on that order?
I just have to look at it. That wasn't on my radar for today. I was under the impression that Judge Hale had already signed an order. And so I will look at that order today, and I anticipate that we'll be able to submit an agreed order. I'm not prepared to do that right now.
Okay, that's fine. And I just wanted to bring it up because I actually looked into anticipating the same thing, that it had already been done, but it wasn't. Judge Hale had just approved us to have an order done. But okay, second is we had the motion to enter a temporary order, Judge, and I believe if we could take that up, that would probably be really quick.
well, my first question on that is whether, I'm assuming that the order entered by Judge Hale on the 11th is what prompted another report from Mr. Maldonado. Does that have any bearing on the entry of temporary orders?
It doesn't have bearing, Judge, but we do need to get that entered as it covers a couple of other issues. But before we can create a new order with some of the recommendations, I think it would be prudent for us to enter the original agreement to a temporary order, and then we can follow up with an amended or a changed temporary order, if you will.
Okay, what I did on
And-
that, just so you know what I did, I looked at the first motion for entry of temporary orders, and then there was a first amended motion for entry of temporary orders, and they were the same two exhibits, correct?
And they were, Judge. The only reason there was an amended is back in December when this was originally set, is when I was diagnosed with COVID and I was really under the weather. So I ended up dropping the setting at that time. So my first amended is just refiling that.
Okay,
But Judge, I also filed a motion for entry of temporary orders. I filed a second amended motion for temporary orders. My exhibits include my proposed order, Mr. Garza's proposed order, and the transcript. So I amended it as soon as I received the transcript from Mr. Laurel. I included that for the benefit of the court.
what was the date of that filing?
January 25th of 2021 at 3:37 PM. And that's also set for today.
Yes, no,
Good afternoon. This is Joe. I'm sorry for being late. I literally just drove in town and walked to my office.
that's all right. We're just going over preliminary. So,
And if I may, Your Honor, for sake of brevity, the proposed order that I had suggested for the court to consider, when Ms. Maddox actually drafted the original version, and I had some issues with it, so I drafted a second version, sent it to her, and she returned it back to me with a lot of proposed changes. I then returned it to her early January, and I did make all but one of the changes that she requested. And the only change that I did not make, and I guess Ms. Maddox is shaking her head, so she gets, I guess, chime in just a moment. But the only change that I did not make was under the child support section, dad is to pay child support to mom. I added all the language for withholding. Ms. Maddox opposed the language and wants the direct paid because we didn't specifically state on the record that it was to be withheld. And our position is that this is codified language. This is a Texas procedure that is put in place for the collection of child support. And I don't believe that this is a situation where my client should be barred from being able to exercise the practices of the Attorney General.
okay, before we get into that, is aside, if that's the only issue, we'll clear it up here in a second. Is there something else?
Yes, Judge, if you look at my motion specifically on page 2, I set out the 1, 2, 3, 4 differences. The first difference was
Hold on.
the Thursday visits.
I'm gonna. I got caught up in reading the other motions regarding the social study that I forgot to print your second motion for temporary entry. So, Mr. Garcia, just so we're all on the same page here, aside from the Attorney General issue and Ms. Maddox I mean, I'm looking at this, it's a 4-page motion, correct?
Yes, Your Honor.
All right.
And so my first amendment to the temporary order would be that on page 7, on the Thursday visitation, we had agreed that it would be every Thursday, and the transcript is clear. It says every Thursday from 6 p.m. to 8 p.m. And in Mr. Garza's proposed order, it says every Thursdays during the regular school term. And my position is that the family code usually has Thursdays during the regular school term, but this is a non-standard possession order. And that's why we agreed to every Thursday. So I understand he's opposed to that, but that's also different in our orders.
And I would agree right now in the sense, just because we don't know what the regular school term is going to be, that we leave that portion out. And I will, at least for the temporary orders, again, this is the temporary orders, that we just leave the Thursday
Right.
language from 6 to 8, because we don't know what's going to happen with the schools. I know everyone's supposed to be back, but just for clarity, let's just leave it like that for right now. These are temporary orders. All right, what's
Yeah.
the next issue?
And that's fine, Judge.
The second,
I'm sorry, I said that's fine, Judge. We can remove the during the school term.
so on B, the child support, the reason I didn't want to do a withholding order, Judge, is because this is a temporary order. And the temporary order, what he's it's probably going to change whenever we have a final order, because right now part of his child support obligation is payment of private school tuition. And so we have a lot of problems with the Attorney General's office whenever we have changes to orders. Mr. Alanis has never been delinquent in a direct payment to Mrs. Alanis. And because this is a temporary order, I would request that the payments continue to be made directly. And then once we have a final order, I don't have a problem with the withholding order, but we have so many issues with the Attorney General's office, and it just puts another party in between to create potential issues. And he's never been delinquent. He's always paid timely, and he will continue to do that. And so I'm asking that for temporary orders, that the payments continue to be made directly to Mrs. Alanis.
Let me hold off on that until I hear, what's the issue then with the added language on the payment of the school past expenses? Is there an issue with that? I mean, is there a past expense?
No, so this is the issue. We agreed that as an additional obligation of child support, he would pay tuition and registration fees. That was the agreement that was made on the record. Respondent has added the language, and any unpaid amounts, expenses associated with the children's participation at the current private school attended by them. And so I think that may or may not incur additional expenses because it's overly broad. The school allows you to pay, they prorate registration fees. So at the beginning of the year, let's suppose registration fees, I can't remember the amount, but let's suppose they're $3,000. What they allow you to do is prorate the registration fees with the monthly tuition amount, and that's what my client does. And so they're technically not unpaid because the school allows for that pro rata payment, and and so I just believe that the extra language gives him an added liability that was not agreed to, because we only agreed to tuition and registration fees. And we know that at private schools, there's other expenses always come up. Maybe not as much now that they're attending school remotely, but I don't want to expose him to that, Judge.
If I may respond, Your Honor.
Sure.
Judge, I'm sorry, but Ms. Maddox's argument is it's flawed in the sense that if the school has made an arrangement with dad and they're breaking up the registration as she stated, then there's no reason for the school to act any differently. If they're going to choose to take it upon themselves and accelerate a particular portion of registration fees or tuition or what have you, then that's on the school. The way we have wrote it is that at the time that the court hearing, the agreement came into place, there was a probability that there was some back tuition or back registration stuff that had not been taken care of. So when the agreement was that dad was to pay the tuition and registration expenses only, I had added other stuff in there. Miss Maddox expressed to me, hey, we limited it to these two items, and I agreed with her. So I made those changes, but there was still the question of unpaid registration that did not have anything to do with this year or that was late coming into this year.
And that was my question. Is there owed expenses for the children's education prior
I think
to?
the best thing to do
No.
is ask the clients,
No.
because unless Ms. Maddox has directly communicated with the school and has it in print, I can't answer that question, and I strongly don't believe that Ms. Maddox can.
Well, look, let me tell you this. Let's assume, just for the sake of argument, if there is, I'm just picking a number, there's $1,000 owed from last year. Wouldn't the children be prohibited from enrolling in the future? And the fact that we have an agreement that he's going to be, the agreement was literally that he was going to be responsible for the children's participation in the current private school. I mean, the thing is that it almost implies that, that anything that might be owed is going to have to be brought up, have to be brought up to be current to allow them to go forward. I mean,
I can ask the parties, Judge, and it's not an agreement that the school has with my client. That's the agreement that they have. That's their contract with all of the parents. This is not exclusive to my client. You can prorate, and so he's paying his contract with the school on a monthly basis that includes tuition and registration. And that was the agreement that we made. And therefore the temporary orders should say that and should not have additional language
Well, and I
that
think
we
Ms.
didn't
Maddox-
agree to.
okay, look, this seems very, very, and I want to just limit this real quick. I want an answer from both sides, whether or not there's any past tuition or registration fees owed from the clients. And let's swear them in so we can get past this issue. Because I think the agreement entered into anticipates that if there was something owed, that Mr. Alanis was going to get that cleared up. But and so I don't see the danger either way in either keeping the language or excluding it. But I'd like to know, since we're on the topic, whether or not there is some tuition or registration fees that are owing. Mr. Alanis and Mrs. Alanis, can you please raise your right hand and be sworn in? Do you solemnly swear that the evidence and testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, and do either of the attorneys have a problem? I'm just going to ask them each one question. Is that okay, Ms. Maddox? Mr.
Yes,
Alanis?
and I think Mrs. Alanis was on mute. And so if she could just be sworn in for purposes of the record.
I saw her raise her hand and nod her head.
Okay.
I said I do. I'm sorry. I was on mute.
Okay,
Thank you.
okay, it's on the record now. Both are sworn in. I have one question, which is a yes or no answer. Mr. Alanis, to the best of your knowledge, are you aware of any past tuition or registration fees owed to the schools of the children?
I am not delinquent in any payments. We are current to date and have always been current. We have never owed in past years or in
That's
presently
fine, Mr.
any money.
Alanis. Mrs. Alanis, to the best of your knowledge, do you know whether or not the children's registration or tuition fees are delinquent for past years?
Yeah, Your Honor, I called the school and they said that since the registration for this school year had
I'm gonna
not been
object.
paid-
I'm gonna object to the hearsay of I called the school.
Do you have an amount, Mrs. Alanis, that they told you?
I gave it to my attorney, and I think they put that into temporary orders, that that amount was not paid before the school year, so they divided it and added it.
What is the amount, Marla? Do you know?
I would have to look through the notes. I know we
Look.
called back in October, was it?
Marla,
I
do you,
can call.
Marla, do you know the amount? Yes or no?
No,
But there is a past due amount.
I was told yes.
Okay,
But you said that it's already been broken up and made part of the current payments that Mr. Alanis is supposed to be making?
Yes,
So whatever it is, it's being taken care of through the
Look,
current.
the easy solution to this is
Your Honor, if I may,
look,
Yeah.
I think, hold on a second. I think the easiest solution is to include language that says is that to include that the petitioners to make all payments to allow the current, under the current school year in regards to registration and tuition.
So what I can do is I'll add to pay tuition and registration fees for the current school year.
That
Well,
allows continued participation in the school year. So if the school decides they need that money in order for them to keep going, then Mr. Alanis is going to be on the hook, because I think that the agreement anticipated that, and that's with any enrollment anywhere, that they won't let you enroll unless you clear it up. And the agreement was that he was going to pay. So that involves past, that's going to be included in that. Now, the question follow-up regarding, was the order, withholding order to the Attorney General going to include those kind of payments?
No,
No,
Judge, that portion of it, that was to make direct to the school.
separately, directly to the school. Okay,
Right, and the way I had worded it is that he would be paying it as additional child support. So he would take care of that. We still had the language in case we had to enforce it. The only collection was going to be on his regular child support.
okay, so we'll come back to B. So D, what's the other request that we have?
The other, yes, D, Judge, was that on the division of property, Mr. Garza included that language that said that Mrs. Alanis be awarded the residence at her disposal and all of the children's personal belongings from each of their prospective rooms. This was not agreed to, and I think it's unreasonable. The children, Mr. Alanis has made the residence available to Mrs. Alanis on, I think, 4 occasions now. They've taken most of their personal belongings and toys, but this is a temporary order. We have not divided the property. They've taken most of their personal belongings, and frankly, it wasn't agreed to. There's lots of allegations going back and forth. And so especially, I mean, we can agree if they ask for things, we can certainly make things available as we always have. But I think it's dangerous to put in an order the residence at her disposal when we've already awarded him exclusive use of the residence and she has exclusive use of her current residence. And so this frankly just was not agreed to, and it's not reasonable.
Your Honor, if I may respond, this.
Yes, and hold on real quick. I want some clarification. I was taken aback when I read that she be awarded, and then you put parentheses to the residence at her disposal. And what were you referring to?
And that's what I was going to touch on, Judge. When Ms. Maddox left the marital residence due to the issues that were going on, she took up residence with her parents. Shortly after that, she started cleaning up and making ready a house that she has now moved into and lives at. So when I say the residence her disposal, she was still in the transition from her parents to the house she's at now. So rather than identify specifically where she lives, I meant the residence at her disposal, the one that she is controlling where she's living at. At no point did I make any connection back to the marital residence. In fact, my proposed order very specifically stated that the marital residence was to be at the sole use and control of Mr. Alanis. So when Ms. Maddox wants to create this huge and dangerous paradigm, it's nothing more than bolstering and just trying to exasperate the non-issue that's at hand.
Well, I'm glad you
Well,
said that because, I mean, we're talking about clothes and toys, right?
Well, no, that would be my, I reserved that part. I haven't talked to that part yet. I've only addressed the residence issue. I would like to address the children's furniture and such. And
then
when I-
Judge, I think it should be clarified to say her residence and identify it, because this way it's vague and unclear. And so, you know, if he would have told me that, then we could have easily clarified this, but he didn't confer with me on that. And so if it's her residence at her disposal and we clarify that, I have no issue with that.
Well, and at this point, Judge, now that she has an actual address, I can add the address to the order. So now we can know specifically what residence. But I will reiterate that the marital residence was awarded strictly to Mr. Alanis for her sole use. So this illusion that it's giving mom access to the marital residence, I'm sorry, that's nothing more than an exaggeration. But as we move on to
Well, that's what it says.
it doesn't say that. As we move on to the children's furniture, Judge, the children are, mom is their primary parent. Mom is designated residence. She now has a new residence, and obviously she needs and could use the children's furniture from their room so they have a place to stay, since this is their primary residence now. My intention was, as is common practice, at least in Bexar County and every other county I've gone to, I won't presume to believe that it's the way it's practiced in Webb, but my intention had been to get the children's furniture and the majority of their items from their room, since this is where they're going to be living and sleeping day in and day out. If that is an issue, apparently Mr. Alanis has huge reservations about any furniture or anything being removed that belongs to the children. If it can't be done here, then that's fine, Judge. We'll file a motion for further temporary orders and we can come back and address that issue. As far as Ms. Maddox's gross misrepresentation of Ms. Alanis having access to the house, I'm sorry. Ms. Maddox is deliberately misleading this court. At no point has Mr. Alanis opened the door, left, and gave mom full access to the house. In fact, he has gone through the house and picked the specific items that he feels belong to her, what he wants her to have, and then has them for her out front so she can collect, or in the garage so she collect. But at no point has Mr. Alanis allowed mom to enter the home and unrestrictedly go about to pick up the items that she needs, wants, or she feels that she will need.
I'm assuming that we're talking about the beds.
Hold on.
Correct. And that's my position, Judge. The beds, maybe a dresser, things that they're going to need to
Judge,
live in this new residence, because otherwise they're tentatively sleeping on the floor and kind of have clothes in boxes. So
Judge, oh
Okay.
my gosh.
Go
The
ahead.
children told my client that they were excited about the new bunk beds that their mother had bought them.
we're going to get into here. Now we have Ms. Maddox.
Yes, look, okay.
Hold on.
And
You can ask the parties, Judge, and I
No,
would ask you to, but the children have brand new bunk beds that Mrs. Alanis bought them for her new home that they were very excited about. Mr. Alanis did make the house available to Mrs. Alanis. I believe he left on 2 occasions and allowed her to, 3 occasions, hold on.
Let your honor
And on,
the parties. Ask Ms.
excuse
Maddox.
me, Judge, if I could,
'cause
Judge, I would just like to be able to respond.
we're
Yeah,
testifying.
I know where you're going with this, Ms. Maddox, and this is the solution we can come to. I would ask.
But he let her go 3 times and took a housekeeper,
not.
and Mr. Garza is
We did
blatantly lying to the court.
Okay, well, and this is why, let me tell you what I'm going to do in relation to this. For the moment, I'm not going to allow Ms. Alanis to take out any more property, but if she feels she does need certain, whatever items, provide a list. Mr. Garza, have your client create a list of what she feels she needs from the house. And we're talking about the old marital house, right?
Yes, sir.
And send it over to Mrs. Maddox so she can present it to her client and see if they can agree on some of those things. And that way, because we could spend all afternoon talking about which chair they're going to take and which computer or whatever. And I'd rather just do it that way. And for the moment, just so we can get some temporary orders on file, the court is going to deny removal of any more items at this time.
Yes, sir.
But we will revisit if, you know, if you all can't agree on that, because if not, we're going to be arguing back and forth as to who let who in and what they need. And we need to get an order in place. All right, what's the next issue?
I think we're back to the.
That's all the issues.
Okay, so that's all the issues. We're back to the Attorney General's. What's the amount of child support that's being paid right now?
1,500 a month, Judge.
1,500 a month. And, or I'm assuming I would have heard already, he has been timely making his payments.
Miss Maddox,
Yes.
Miss Louise, yes.
Why do we want to rock the boat on that issue, Mr. Garcia?
If I may, Judge.
Yeah, I know you're going to tell me that that's,
No, Judge,
this divorce has enough problems already. And if it's working right now,
if I may, I'm not trying to rock the boat. What I am trying to do, Judge, is as an attorney, my job in defending my client is to always prepare for the worst case scenario.
worst case scenarios.
And at this point, Judge, at some point, and I can't predict the future, so I don't know that Mr. Alanis isn't or isn't going to pay his child support. But if at some point he elects not to or starts to delay and push further back the days he's going to pay, then I would have to come back to the court, file a motion for further temporary orders to add in the language that would permit my client to be able to go to the attorney's office to seek collection, so forth and so forth.
Which would take more time. You would have a quicker response coming to this court if in fact Mr. Alanis was late in his payments.
Correct, which is the reason that the order does contain the language that unless he reaches a point where he's 30 days late, then it continues. Once he hits that point, then mom has the ability to take that.
So I'll meet you halfway, and this is what we're going to do in relations to the Attorney General's office.
Yes,
Mr. Alanis, if Mr. Alanis is late even 10 days on making his child support payments, the court will then order all future payments of child support be made to the Attorney General's office. And that way, he's got some incentive not to be late. So we'll do that in relation to that. So include that in the temporary orders. So for now, Mr. Alanis will allow you to continue to make direct payments for whatever excuse, I don't care what it is, COVID or otherwise, in the event that child support payments are not made at the latest, the 10 days, they're going to have the right to go to the Attorney General's office. And this court will order all future payments.
I understand, and I've been tendering payment a week prior.
So,
No, I
Judge,
know you have, or else I would have heard about it already. So
at this point, do you want me to remove all of the collection language and then just add in one bullet that in the event this happens, you reapproach to have dad pay through.
If you would, and I'm assuming we can do that without having another hearing on this.
Yes, sir.
Okay, so now, does that take care of the motions to entry of temporary orders?
Well, I guess the only other decision, Judge, I think you're gonna need to make is,
The Christmas?
no, no, given the fact that, and my position would be that I'm the one that's pressed the issue. We're the ones that's pressed the issue on temporary orders. We filed the initial motion temporary orders. Can we make the changes to my order and I will circulate to Ms. Maddox and Mr. Maldonado? Or are we gonna work off of Ms. Maddox's order, make changes to that? Because she equally has the motion to enter in place.
Who wants
Worked off
the
of his
extra work?
order. I converted his order and worked off of his, so it makes no difference to me. If he wants to do that he can make the changes and circulate it to me.
Perfect. That'll
take-
take care of that.
Next, Judge, I think it'll be quicker if we deal with Ms. Maddox's motion to request a social study. And Your Honor, I'm deliberately leaving the discovery stuff to the end because Ms. Maddox and I went through that long list and we've kind of cut it down, but we do have quite a few issues that we'll need your direction on that could go relatively quick, but these will probably be quicker.
Well, I will tell you, I think I got through 90% of, I was in the last few of the request for production and I ran out of time, but so yes, I think that will go relatively quick. So what's the issue with the social study? I mean, we see that ordered regularly. What issue do we have with the social study?
Your Honor, our position against the social study is this. We have Mr. Maldonado on the case as a guardian ad litem. And the family code basically directs him to be investigating all the issues, looking into visiting with the children, and ultimately make recommendations back to the court via a report. At this point, if we were to bring in a custody evaluator, somebody that is going to do or mirror Mr. Maldonado's job and equally writes a report, then the potential for having conflicting reports creates in my opinion, a big mess. Because if the case ends up going to trial, then we're going to have a judge or potentially a jury. A trier of the fact is going to have two professionals that are going to be sitting there contradicting each other. Now,
Don't we still have Mr. Jesse Hernandez visiting with the children?
yes, we do.
Okay.
Yes.
And Mr. Maldonado obviously is.
Look, and I don't want, yeah, and I tend to agree with that argument, Ms. Maddox.
If I may, Judge?
Yes, briefly, please.
So a social study is much more involved than the role of a guardian ad litem. And the Texas Family Code dictates what kind of professionals are qualified to do a social study, including investigating the homes of all of the parties requesting conservatorship. The purpose is to gather information, opinions, and recommendations. And on multiple occasions, both Mr. Hernandez and Mr. Maldonado have told me that they are limited by their role in their case and they are unable to investigate the home environments of the children. And that's why I'm asking for that. In addition, attached to my motion, I have texts from both Mr. Maldonado and Mr. Hernandez. And additionally, Mr. Hernandez has sent me another text because of the issues with the children. He says, hey, I'm just here for the children. I can't, Mr. Maldonado is also here to represent the interests of the children, but an independent opinion about the home environment of the parties and the home environment of the children would be much more helpful in this case where custody is in dispute. In addition, there are issues of triangulation suspected by both Mr. Maldonado and Mr. Hernandez. And they say, we can't investigate that because that's not our role. And so there's a gap in some of the investigation that's required in this case, Judge. And that's why I did it at the recommendation, frankly, of Mr. Hernandez. who said that that would be helpful to him as well, and Mr. Maldonado.
Well, and Judge, if I may, first of all, Mr. Maldonado has visited with the children at both residences. So to have Ms. Maddox stand here and say that Mr. Maldonado does not possess the ability to investigate or to go into or sit at the home, wow, that's just wrong. As a matter of fact,
He's not qualified under the family code, Judge.
I
as a
know,
matter of fact, we
well,
had
yes, is that even in his last report, he indicated that he did a surprise visit to Mr. Alanis.
and that's where I was going with
And
that.
not to Mrs. Alanis. And a social study will actually investigate all three households, because right now the children visit with Mr. Alanis. They live with Mrs. Alanis at her rental property, but every day they travel to their maternal grandparents' house, or I don't even know. They're shaking their head no, because we don't even know that. We don't even know where the children spend most of their day, because we're not provided that information, not by Mrs. Alanis, not by Mr. Maldonado, not by Mr. Hernandez. And so we need information about the home environment of the children that we're not receiving from anybody else in this case. And Mr. Maldonado, with all due respect to him, he's a lawyer. He's not qualified under the Texas Family Code to conduct a social study. He doesn't meet the requirements in the code to conduct a social study.
And Your Honor, I think one important piece to point out here is that up until the incident, I believe it was January 7th, that took place, that prompted our motion to seek further temporary orders that Judge Hale wanted Mr. Maldonado to look into and then bring back a report. Up until that point, this had not been an issue. However, because of what was happening, and there was another incident, I believe there was a COVID directive or something that came from the city, and Mr. Maldonado had made a suggestion about tailoring visitation a little bit different. Ms. Maddox took very big opposition to that suggestion. And then in response to that, there was an email that she sent to Mr. Maldonado that I was CC'd on, where she threatened court intervention and filing documents because of his suggestion. And this was the result, was the request for the social study. So in our opinion, this is not a need because Mr. Maldonado is not qualified or hasn't visited the homes. This is nothing more than Ms. Maddox and Mr. Alanis not liking the results of Mr. Maldonado's investigations, his visiting with the children, his visiting with Mr. Hernandez. And so they're attempting to bring in more experts that could potentially end up in conflict with Mr. Maldonado's work because they don't like it. And this is not the way to do it. You don't try to continue appointing different people to muddy up the waters and create a bigger problem.
Judge, it's a completely different role. And what I said, Mr. Maldonado suggested that because of the last outbreak in COVID, that the children, that we suspend the visitations with Mr. Alanis. And I told Mr. Maldonado that that was contrary to the Texas Supreme Court order and that I could not agree to that, and that the court had not asked him to impose visitation limitations, but only to make a recommendation. And so I was opposed to suspending visits based on the current surge in cases in Laredo. I'm happy with his reports. I think he's done a good job, but he and Jesse Hernandez has been telling me from early on in this case that he wanted a social study and that he thought a social study would be done. And consequently, Mr. Maldonado has agreed with him. These are different roles. A social study doesn't represent the children, doesn't represent the parties. Mr. Hernandez counsels the children. Mr. Maldonado represents the children. A social study is unbiased, who investigates the living conditions in the children. They just don't. Why do they not want us to investigate that? We don't even know where the children spend the night or spend their school days, because that information isn't even provided to my client, Judge. And
That's
so
right.
Hold on a
absolutely,
second.
we need a social study.
Mr. Alanis has no idea where the children sleep every night. That is true. He has no idea where the kids go to school. He has no
All right.
idea.
All
who
right,
they-
Mr. Garcia.
I didn't say that.
All right, let's do Mr.
Why don't we
Mr.
ask Mr. Maldonado, Judge? I mean, he's
Yeah.
sitting right here.
Mr. Maldonado, I thought I had your report here, and I just briefly went through it again. Here it is. Yep, one other question, and I know this is probably, what is your final pretrial? Do you have a final pretrial guideline order in this case? Oh, no. I
Not
mean,
yet, Judge.
Yeah. Mr. Maldonado, did I miss the part on your report regarding social study?
No, Your Honor, candidly, that wasn't what the judge had asked me to do. With respect to the social study, I'll tell you what I told Ms. Maddox, is that I'm not opposed to a social study because for me, more information is always better. I guess what's the living situations in this instance, I guess, have been a little fluid, but I think have gotten a little more concrete recently. I think it was a period of transition based on what I'm looking at, but I know that the children are now living at the address where mother lives. I think it's a Farragut address. And then from my understanding, this semester, which I guess began either the late first week of January or beginning second week of January, what happens now is that the maternal grandmother and then sometimes maternal grandfather will go to that house and supervise the children while they're online learning there. That's my understanding of the arrangement. The children are no longer moving from house to house is what had been my previous understanding.
Well, and let me, I guess, suggest this to you, Ms. Maddox. I mean, based on what I heard regarding the furniture and all this, I want to be
It's
fair
also,
to,
Judge,
I want to be fair to both parties to establish the new home that Ms. Alanis is working on.
it was recommended by Jesse Hernandez. He said that it would be helpful.
It was not
to
recommended,
him.
Judge, and I'm going to object to hearsay because he's not here to state it, and that is not at
Well-
all the way I understood it. He
Well,
didn't recommend
I'm
it.
an officer of the, I'm
And-
an officer of the court. I am not lying, and I can produce the
Yeah.
text where he says, I think you need a social study investigator.
And does this
All right,
have,
let's do this because, again, Mr. Garcia, I'm denying her motion right now, but you got to understand that it's not like she's asking for anything outlandish.
no,
Social,
and-
social studies are done all the time.
and I don't disagree with you at all, Judge. It is not uncommon, but it has become my experience, and I've been in situations where I've taken over cases where both were done. They were conflicting, and it created a huge mess.
Well, yeah, and
Well,
that's,
but both Jesse and Joey have said that it will help them in this case. And it's not about Mr. Garza. It's about the children, and both the children's therapist and the children's guardian are saying they think it would be helpful in this case. And I don't understand. It's curious to me why they wouldn't want a home investigation of
Because
both
we have Mr.
parents.
Maldonado
And
that has been doing the exact situation, and his report reflects that.
Judge, Mr. Maldonado has visited with both parties once and only with my client this last time. He said that he was going to visit with both sides, but that's not his role. His role is not to conduct a social study, and he's not qualified under the family code to do so.
Well,
And-
okay, look, and let's look, based on the motions that I was reading today, there's issues going on, okay? And I don't know what it has to do with, but what I would like to do then, Mr. Maldonado, I mean, how, do you have access to Mr. Jesse Hernandez?
I do. I speak with him pretty frequently about this case.
Have him do this, and I want it in his hand, not yours. I mean, you can mention it, but I want some indication of what his position is on the social study before I grant it, and whether he thinks that right now is the time to do it.
Your Honor, if I may, I've had that conversation with Mr. Hernandez. His position is a little stronger than mine. He thinks the social study should be done, as Ms. Maddox has said. I'm not opposed to it, as I mentioned before. My general experience is that I will take a social study as the guardian ad litem and use that information in making my recommendations to the court. But I kind of see it the same way with having Mr. Hernandez as the counselor. He's the counselor talking to the children, giving me his diagnosis. I cannot make those diagnoses of the children. And so I use it as a tool in my recommendations.
Judge, equally, we need to keep in mind that the clients are paying the counselor, they're paying Joe Maldonado, and now we want a social study or custody evaluation, excuse me, because they're not happy with the way things have been going. At this point, Judge, if the court is even considering this, I strongly am going to request that it all be at a 100% expense to Mr. Alanis, as this is nothing more than retaliatory to the position that Mr. Maldonado had taken. And I will state that Ms. Maddox was grossly incorrect. He never stated to postpone or to cancel visitations. He suggested moving visitation from one weekend to the next weekend. That's all that he did. That's all he did was let's slip it by 7 days. And Ms. Maddox chose to take a retaliatory position by filing this document.
And what Mr. Garza said was, we're not going to give you that makeup visit unless the court orders it. And so, and we've already had like we've already had three missed, hold on, if I could finish. Excuse me,
I
I'm
was
speaking.
present at that hearing, and I remember distinctly that being an issue when you were sick, Mr. Garza.
No, she's referring to the suggestion that Mr. Maldonado made about slipping the weekend in January, Judge. But if we're going to start accusing me of lying, I want us to move into an actual hearing so we can present emails on the record.
No, look,
because
so far, well, I'm not going to deny anyone the right to do that, but
Judge, because I did not do that. What my response to Mr. Maldonado was, Marla will totally agree and cooperate with any suggestion you have by slipping the visit weekend to the following weekend, which in turn, Ms. Maddox and Mr. Alanis were so blinded by it, Judge, that I will tell you, Dad would have ended up with 3 weekends in a row because it would have gone, it would have gone to the 4th weekend, the 5th weekend of January, and then the 1st weekend in February. So he would have had 3 weekends in a row had he agreed to that. But he was so determined, as was Ms. Maddox, to have the visitation that weekend that they strongly, emphatically took a position against Mr. Maldonado's suggestion based on the COVID situation on Laredo and filed a motion for custody evaluation. That is the truth of how it happened. And I can produce that email.
I can pull up the email.
Let's stay on what we're on here. Let's finish off with the social study. I'm torn by the fact that, again, social study requests are not outlandish. And that's regardless of the motives. I mean, this is something we see all the time. Um, and I hate late, I don't want to leave anything hanging, but we may have to do this. Is there anything, this is what we'll do. I don't care who it comes from, but if there's a report out there from Mr. Jesse Hernandez regarding the issue of social study, the court will consider it at that time, whether or not we're going to grant the social study. But if we do grant the social study, Ms. Maddox, then
I'm not sure if I have permission to share screen, Judge, but I seriously take very personally when
I
somebody.
have it right here. If you can share the screen, I'll show it.
I'd like to show screen to determine, to show to the court that recommendation that weekend, I told Miss,
It says,
I told Mark.
makeup visit weekend is fine, and I'll show it.
Ma'am, I don't want
You know how-
anybody to read it. I would like to show the email.
Okay, can I share the screen,
we're in
Judge?
agreement with.
okay, let me finish on the social study, and if
I can show it with my camera right here.
Oh my goodness.
okay,
Is that the way it works?
It says,
You're
makeup
denied-
visit
You turn around and.
next weekend is fine, subject to your recommendation as directed by the judge. That's exactly what it says.
Right,
Okay.
subject to that is what Judge Hale
What I
said.
just said, subject to the judge.
No, you said I wouldn't agree to it. I told you I
look,
would.
we could, look, so let me finish on the orders of the, I will order, if the court does order the social study, Ms. Maddox, since you're requesting it, I'll order that the petitioner pay 75% of that and 25% for the respondent. And I hate leaving it hanging like that. But
So you want like a memorandum from Jesse Hernandez on his position on the social study?
yes,
Okay,
and the court will rule on its own motion once we get something along those lines. And if it does, I'll remember, and I'm writing it down now. It's going to be split 75, 25%. Are we ready for the motion to compel?
Yes, sir.
yes,
Your Honor, may I ask,
yes, Your Honor.
if the
Yes.
parties don't need me anymore on any of the issues, I'd like to be excused, although I'm happy to stay on if they need me.
No, if we're going into the motion to compel, I don't think we, unless any requests from either side.
No, I'm fine, Judge. I don't believe he needs to stay.
Okay. Thank you, Mr. Maldonado.
Thank you, Your Honor. Everyone stay safe.
Thank you.
Thank you, Joey, you too.
How many of all the,
Do you want me to start with the agreements that we made?
well, if we start, I guess with his motion to compel starts with the interrogatories. Interrogatory
Okay.
number one,
Yeah.
list of,
I've,
And we have, I'm sorry, Ms. Maddox, it's my motion, if you don't mind too terribly.
go
well,
ahead.
go ahead.
Actually, Judge, if you just begin, number one, we're asking for witness identification. There's the objection. And then I believe,
Is that not agreed to?
I agreed that I would withdraw my objections and include C, request for disclosures, because it's duplicative of the disclosures. And in the disclosures, I included all of the witnesses with their contact information and what they would testify about.
Ms. Maddox is correct, Judge. I made my notes and I forgot to add the word that she was withdrawing the objections. That was my mistake.
Okay, yeah, 92 3D specifically allows for a list of witnesses at trial. All right, so that one's taken care of. Number three,
Actually, number 3 and 4, there was an NA is unapplicable, but I believe Ms. Maddox was going to remove that and provide actually some type of response. Is that correct?
He was satisfied with, instead of NA, me changing it to none. So that's on number 2, 3, and 4. I'm going to put none.
well,
Oh, I'm sorry, 2's not in the motion, but I'll do that for number 2 as well.
3 and 4, okay, moving on to number 5.
Number 5. Number 5, actually, number 5 and 6, Judge, Ms. Maddox had agreed to identify some items that were, well, she's basically gonna modify her answer to something we agreed to. The only position was the objection. We felt that the objections were inappropriate as this is discoverable items, so there shouldn't be an objection. Ms. Maddox felt different.
Actually,
Well, my reading of it actually is that this is kind of overly broad. But if
Yes.
you've reached an agreement as to specific ones, I mean, that's quite a laundry list there, Mr. Garcia.
Well,
we
Judge,
did not,
if I may
we
preface.
didn't reach an agreement on that one. I was standing by my objections on 5 and 6 because I thought they were overly broad. And not only that, it is sufficient, it's overly broad. And I'm referring to documents is proper when in answering interrogatories. And so the objections speak for themselves, Judge. The documents speak for themselves.
If I may, Your Honor.
Okay, well, yeah,
Judge.
I don't want to backtrack on the agreement on here, but,
Judge, if I
Didn't
may,
have an agreement.
please.
okay, go ahead.
Okay, then Ms. Maddox, we have zero agreement on this because I thought we had one, but if we have zero agreement, then let me know now.
We didn't have an agreement on 5 or 6 because
Okay.
I was standing by my objections that that list was overly broad.
Okay, so with that said, Judge, first, let me preface by stating that these were not my discovery requests. Prior counsel produced these, and I had expressed to Ms. Maddox that I would have done something completely different. Nevertheless, with stating that, we're not asking, this is not production, this is interrogatories. So at this point, we're merely asking, if I read the question, they're asking for a written log or a description of any items and the location of said item that would be relative to these issues. These are all issues that are part of this case. So when you're asking to identify documents, you're permitted to ask in multiple parts in an interrogatory, especially if it consists of all the items that are related to and are issues that are material in the case. That is straight out of 197. So with that, I disagree that it's overly broad. It is very specifically covers the issues that are part of this case. So with that, the objections are inappropriate because these are related to the case. And second, they're not vague or ambiguous or unclear.
Let me tell you what my concern, and maybe I'm looking too far into the future.
Yes.
My concern is that the way this interrogatory reads, that if you're in trial and there are documents that may have been produced or not asked for, and that can be somehow fitted into this request, that there's going to be an objection, which is why basically the objection, which includes having to marshal so much evidence, I think is proper because it's so overly encompassing on the entire case. I mean, she's going to have to go back, and if you can narrow it down to certain items, I wouldn't have had a problem with it. But the way this is written requires so much information to go in there that could be objectionable at trial, that the court is going to sustain that objection. And the same goes for number 6.
I guess at this point, Judge, given that I didn't write these, I know this is kind of going outside the box a little bit, and I admit
I
that
know what you're going to ask.
before I stated, but would I be allowed or permitted to rewrite this request and allow, because I guess the other problem is this, Judge, and I did tell Ms. Maddox this, I rarely never make 25 interrogatory requests because I leave myself room given the answers I'm going to get. Previous counsel utilized all 25. So I don't have any more to ask. So I don't know if the court would allow us to reword this to make it more usable and then grant Mr. Alanis the 30 days he's entitled to respond. Because otherwise we're stuck and lost the ability to use the interrogatory.
Well, that's not currently part of his motion, Judge, and I would object to going beyond the 25. I think that because of the discovery requests that that Ms. Cigarroa propounded upon my client, I have complied. And just because I have a good objection doesn't mean that he should be given more discovery requests. In addition, under the local rules, we are required to exchange sworn inventories, which we don't have a deadline to do. And so I don't think we should make it more burdensome and more expensive for these parties by opening up more discovery.
And Mr. Garcia,
And
let me tell you what you are free to do, because I saw parallel requests for production regarding these items, which I think will accomplish what you're trying to do here with the interrogatories. And actually, I think they'll be more appropriate at that in reissuing requests for production.
Right. And that's fine, Judge. I mean, I kind of wanted to use Ms. Maddox's argument again about the double work because of the interrogatory and increase in expenses, but I thought that's what she was doing by asking for a Schuster study on top of the Guardian ad litem. We're doing double work. So, I mean, obviously, there's no concern for expense on that end. I can't see why there would be a concern.
Okay. All right, let's quit with the
Again, they're different
sideboards. Sideboards aren't going to help anyone.
Okay,
Right.
but if
Move on. I've ruled on number 5 and 6. What about number 7?
these are denied, correct, Judge?
5 and 6 are denied.
Okay,
I mean, the objections are sustained. Yeah, your motion to compel on them is denied.
right, okay. 7 and 8. Uh, 7. I don't know,
number
Ms.
7, I agreed that I would remove the objection and amend my my response to say that Dr. Emmanuel Martinez is the treating physician. He doesn't have any records in his possession. Jesse Hernandez is the children's counselor, and we don't have any healthcare records currently in our possession.
I don't, no disrespect, Ms. Maddox, but I don't think we need the long dissertation, what you're gonna do, just a simple remove
Okay.
objection.
Guys.
I'm just trying to be
unless I have-
helpful so that,
Yes, unless I have a problem with the response, please don't correct either side.
Number 8, I believe.
Yeah.
Number 8, Ms. Maddox, did we agree that you were gonna change that answer as well? That's when you had it.
And actually, yeah, I wrote a note on this. Yeah, this does need to be answered. I mean,
Which
it may
one?
be number 8.
Private investigator thing.
oh yeah, I was gonna amend that to write none. I thought that not applicable meant, under the definition of that, but
Okay.
I will write none. He doesn't apply, it doesn't apply because he didn't hire an investigator, but if that's not clear enough, I will write none.
Good Lord. Okay, never mind. We'll just keep going through all the rhetoric. Number 9.
Objection to the sidebar.
But
That's
This-
all
this
you've
actually
been doing, Ms. Maddox. Okay, number 9, Judge, from 9 on for a few, I want to say through number 11, we had a disagreement on experts. This particular question asks if you have used any expert for consultation who is not expected to be called as a witness, if that expert's opinion or impressions have been reviewed by any expert who may be called to testify. So as far as I understand the rules, the expert that's going to testify, okay, anybody that has been used for consulting or that expert has reviewed their info or any connection to them that is not testifying, then those experts are fair game. And you must produce any information so we can contact those experts to figure out what exactly was provided to your testifying expert. And that is what this next series of questions ask. So
if, yeah, I did review that just to make sure. Yeah, purely consulting experts are protected, but if their information is introduced and used by any testifying expert, then they do have to be identified, and the information reviewed by the testifying experts is all fair game. So
That's correct, Judge, but the rules are clear that that is under request for disclosures only. You only answer discovery about all experts pursuant to requests for disclosures. And so putting it in an interrogatory not only makes it duplicative, but he's asking for additional information that goes beyond the rules of the request for disclosure and puts an extra burden on my client. Rule 194 and 195 very clearly states that all discovery regarding experts has to be disclosed through the disclosures. And so it's an improper, overly burdensome form of discovery on my client.
And I would disagree, Judge, because specifically 194.2, I'm not sure the subpart, but in this case,
I reviewed the scope of discovery, and I agree, Mr. Garcia. The consulting experts' information is discoverable if reviewed by testifying experts. So, and although there is a requirement under disclosures, Ms. Maddox, that there's no limitation. I don't think there's a limitation if he wants more detailed information. If they, again, the consulting's opinions have been or impressions have been reviewed, and that's what he's asking for here. So.
But he's not, it goes beyond the Robinson motions, and we don't have a pretrial guideline order. And so then I'm gonna have to comply with our guideline order and with the discovery requests in addition to the disclosures. You see what I mean?
These should have been disclosed anyways. If
they are, that's what I'm saying. I've answered them in disclosures. And so why do I have to now answer them again in interrogatories and provide additional information that's already covered by 194 and 195 disclosures?
and I will represent to the court, Judge, that in disclosure, it's asked specifically for testifying experts. And the only answer I have for Ms. Maddox is none. So no, I'm sorry. She doesn't cover that information in
Because there's
disclosure.
none. There's none.
No, and hold on a second. And yeah, and then the answer might be that there are no consulting experts in this case. What I'm saying, if there isn't, well, he needs to know, but if there is, and their opinions and impressions have been used, then they do have to be disclosed under these interrogatories, Ms. Maddox. But the answer may come back that none have been used, and which is, but I don't think this is an improper request, either 9, 10, or 11.
So those are granted, Judge?
Yeah, those are granted.
Okay. Moving on to 12.
Wait, hold on. Where's?
Number 12, I'm going to sustain the objection on that one. Again, that's straight from 192.3D, subpart D. I mean.
Yes.
192.
192.3 subsection D. Now, Ms. Maddox, you mentioned inventory, and actually in the next few requests for interrogatories, and then this goes to both sides.
Judge, I'm sorry. I don't mean to interrupt, Judge, but I'm looking at subpart D, trial witnesses. A party may obtain discovery of the name, address, and telephone number of any person who is expected to be called to testify at trial. This paragraph does not apply to rebuttal or impeachment witnesses. Now, so looking at this question, and Ms. Maddox and I went over this, I understand that at this point, she doesn't have impeachment evidence or impeachment information because we're so early on in the case. So her answer is most likely going to be none, and I acknowledge that. But to sit and object to, or to have an objection to very information that we would be entitled to if we request it, that is my issue with it. Because at this point, if the objection is sustained, then she has no duty to supplement because you sustained her objection. So she can hide behind that objection, and then we're get hit by trial by ambush, which is the very reason this discovery rules are written.
No, I don't think so. I think you're reading more into that, Mr. Garza.
Right.
The rule is pretty clear. I don't know how many times, one way or the other, I've seen that, that
Yes.
rebuttal or impeachment witnesses do not have to be listed on the disclosures. So I think you're trying to get more through this interrogatory. So the rule has been sustained. So let's move on to 13.
Judge, if I may, one last point. I don't disagree with you that the disclosure rules doesn't apply to rebuttal or impeachment witnesses. This is the reason that it's asked for in interrogatories, because disclosure doesn't obligate you to produce that information. But if I ask for it in an interrogatory,
Seriously,
I'm sorry?
I see what you're saying. I mean,
But the rule is clear. It's 192.3D that.
Right, and again, I don't disagree with you. And in that rule, it does not apply to impeachment witnesses or information. That is why it's requested outside of disclosure, because disclosure prevents you from obtaining it there. But that does not preclude me or any attorney from making the same request in an interrogatory.
Huh? And the rule does not require me to speculate about that before trial. And the case law says that too.
And again, as I
you
stated,
know, I'm going to agree for right now, but you bring up an interesting point, Mr. Garza. For now, my ruling is going to stand. The objection is sustained, and moving on to 13, and I'm going to throw this out there. It seems to me that a lot of these interrogatories coming up could have been answered if the parties had been ordered to turn over an inventory.
Well, but keep in mind, Judge, if you turn over an inventory, you identify assets. In this particular case, 13, for example, it's asking for each item of property owned by the community estate or a separate estate, describe the property and give other information. First of all, you can't object to these items. This is not objectionable question.
No, I didn't say that it was objectionable. I'm just saying that I'm trying to save both of you all
Right,
some work.
but in an inventory, you identify the
No
items.
Look, no disrespect to the Alanises, but well, we're not talking about a $10 million estate here. At least I don't think we are, but I haven't gotten that impression.
Well,
I put out there, look, and I'll rule on each one of them. I'm not saying that this is an unreasonable request. It just seems that a lot of the information that we're going to cover in a little bit would have been resolved by because I'm not really seeing, there's very little here that would not be answered by an inventory.
Well, Judge, but an inventory, I mean, I don't know how if there's a specific inventory that is mandated by local rules in Webb County, and I'm not going to know or say that I've done my due diligence and looking at the local rules, which I haven't. But most inventories that I'm familiar with, you put down, you list your items, but you don't necessarily go in and describe what is separate, what you contend is separate.
No, we do require that.
Okay.
Okay, so, well, how do you all want to,
well,
how do you want to?
but this is my issue. Can I at least give the reason for my objections, Judge? Because it says for each item of property, that's overly broad, because each item of property that's community or separate, I have to include every piece of furniture, every piece of every watch, I mean, it's asking for everything that they own. Item by item, every single item. There's no way I can do that, Judge. And not only that, I'm not going to know until discovery is complete. And I don't know what the percentage of ownership is right now. And I couldn't possibly know of every item. And so it would be more appropriate it covers every single thing that they own. It's not related to real property. It's not limited to automobiles. It's not limited to property over a certain value. And so based on this request, I have to list every single thing that they own.
And I'll remind the court, Judge, that even trying to get children's furniture, Ms. Maddox and Mr. Alanis are very combative on even turning over anything. And they have my client unfettered access to the house. So at this point, we can only take the position that Mr. Alanis is going to contend that everything inside the home, which includes all of the furniture, because my client has not been allowed to take any furniture from the home, that he's going to contend that he'd be awarded all of it. But I don't know that for a fact until I have it through interrogatories. And that is the purpose for interrogatories.
But he's not asking for furniture. He's asking for every single item that they own. And because he brought it up, Judge, we've let her have access to the house. Let me finish. We've let her have access to the house 3 times. She never, one of the times she made a list. If I could speak without being interrupted. One of the times she took a housekeeper with her, another time she made a list, and she never put items of furniture on the list, Judge. These are temporary orders that we have going on right now. And the kids bragged about the bunk beds that they bought at their new house. And so he's trying to detract from the fact that his request is overly broad. Every stick of property that they own could not possibly be listed in an interrogatory.
And once again, Judge, if they want to take the position that they need to identify every stick of community property, that's on them. Second, Judge, I will reiterate that my client has not been given unfettered access to the home, but Ms. Maddox is correct, and my client did go to the house with help of others to pick up items that Dad had bagged up and put out in front of the house, but did not permit her to go in the house. And again, I'm sorry, Miss Maddox was there during the exchange, so I wasn't. I'm in San Antonio, so I didn't see it. I guess Miss Maddox can tell us if she was there and physically saw herself that Mr. Alanis opened the house and left and allowed Miss Maddox unfettered access. Is that correct, Miss Maddox? You were there?
Look,
Judge, you
I'm
can
gonna
ask
get
the
into it. Look,
parties.
we're
I'm
kind
gonna
of
object to
discussing.
the sidebar and the personal attacks, but you
Well,
can ask Mrs. Alanis if she had access to the house while Mr. Alanis was gone and how many times.
that's going back to the
She's
discovery.
under oath. She can answer that. She
Going
can
back
answer that.
Yes,
But
all right. Look,
Going back to the
back
discovery.
to this, it
let's
says
go back to the
for
discovery.
every,
All right, hold on,
it
Ms.
says
Maddox.
for each item of property, each item of property. That's what it says.
Going back to the discovery, Mr. Alanis, as he has the right to be able to list whatever items he feels he needs to list. And that's what the purpose of this is for. If there's items he doesn't feel need to be listed, that's his prerogative. And then it's our job to police and to go on from there. But at this point, Judge, we are entitled to have him list property that he feels is owned by the community or by separate, assess what values he believes they are, and then general theories, both factual and legal, as to why they would be separate or community. And we're entitled to this information. He should be obligated to answer the question.
All right, let's do, okay, let me tell you what we're gonna do in reference to this. And this goes for 13, 14.
And believe 16 kind of loosely ties into
Let's see.
13 and 14.
Yeah, I think this is gonna go into 13, 14, 15, and 16.
16 has no objection, Judge, and it's answered.
Okay, is that correct?
No, 15 was one that I
I'm
had.
sorry, 15.
I had removed 15 from our list, but when Ms. Maddox,
15, yes.
so I was removing 15, but it's 13, 14, and 16.
All right. I think Mr. Garcia is correct in the general sense, but again, I have a problem with having, as indicated by Ms. Maddox, how much detail we're going to have to get into in reference to household items. I truly hope that this is not going to be what's holding up a proper division. I'm going to hold off ruling on those interrogatories. And I think there were some requests for production after both parties have produced an inventory. And I'm going to give each party 45 days. And I'm going to look personally into the form, because I know we have one that was circulated. It's not used very much. But I'm going to make sure that it covers what we need to cover in this, and both parties are going to be ordered to respond. And if we need to come back and address these interrogatories and the request for production, we will do that.
Understood. However,
I will tell you that the practice here had been that, myself included, was we would include household items in a lump. And I never caught any grief on that. Now, if the parties are intent on fighting for every chair and shot glass, which I have seen, then we may be in a position where both sides are going to have to provide a more detailed inventory to get through this divorce. So before we do that, I'm going to allow both sides to generate what they believe to be an accurate inventory, before coming back to these, knowing now that this is going to be an issue. Okay, so and remind me when we get to the request for production, because I remember there were requests for production that kind of mirror that.
Right.
So we're done with
Through 16.
13 through 16 because 15 was agreed to.
Judge, if I may, on the inventory side of it, my client obviously is going to need access back into the house to be able to do her inventory. So I would like to have, I guess if we can agree on a date with Ms. Maddox and Mr. Alanis where we can have access to the home, and I may actually drive down to Laredo to do this with my client.
This is how we're going to handle this, Ms. Maddox. You're going to give me, before I send out the inventory, which it won't be today, hopefully tomorrow, before you will give me a host or a few dates where they'll be allowed into the house. To make an inventory and then.
Yes, Your Honor.
And then that way, and I guess what we'll do is,
Do they
actually, you should
prefer
send it to me and
if
to
they-
Mr. Garcia.
I'm
Send it
sorry.
on-
Okay. Do
I'm
you
sorry.
prefer weekdays or weekends? I'm asking Mr. Garza and Ms. Alanis just so we can make it easier for them.
To be quite candid, I mean, weekends obviously would be a little bit easier, but it doesn't matter. If it's
Okay.
during the week, I would just ask that it be maybe after lunch sometime.
Okay.
And just so we don't have to come back, the access will be limited to an hour. And no items will be allowed to be removed.
Correct. Okay. Move on to 17.
Okay, 17.
I agreed that I would amend my response.
Okay, good.
So 17.
Agreed. Number 18.
I agreed to withdraw my objections and I will withdraw my objections and stand by my response.
And that's correct, yes.
Okay, number 19.
19 and 20, there was an agreement that she would change. Or
Not
amend.
applicable to none.
Okay.
And then 21 and 20. This one, this goes back to somewhat 13, 14, and 16, Judge, although this talks about reimbursement claim. And at this point, one, I don't believe, let's see, I don't think there was an objection. There was no objection, but the answer, she's telling information to this interrogatory may be contained in documents produced or made available. Well, first of all, when you say may be contained, it's not my job to go hunt it down, decipher it, and then try to understand what is going to be relative to your
Well,
claim.
let me tell you my reading of this. I kind of see this as an economic damage. So he's really asking for a number.
Well, we're asking which estates, first of all, would have a claim, whether it's either one of the separates to the community or the community against one of the separates. And then we're asking for the nature of the claim and then how much.
Judge, I will amend my response, but I'm not going to know until we conduct further discovery, and I will include that in my response because I have a motion to compel drafted, but I told Mr. Garza that I was not going to file it until he and I had the chance to confer on it. And so since discovery, I will amend my response, but I'm not going to know everything until I know what all the accounts hold and I've seen
Sure.
all the transactions go back and forth.
Yeah, it is just a warning from the court that reimbursement claims, I think falls under the required disclosures for economic damages, so that I think this is a proper, both of them were proper interrogatories, and there's no objection, so you might want to be careful with this, Ms. Maddox, because
Yes, Your Honor.
there are actual amounts that he's asking for that I think they're entitled to know.
And because discovery's not complete yet, Judge, I don't have those amounts.
No, I understand that. I understand that.
Right, and equally, Judge, her answer was, the dad's separate estate from the community. The claim would be investment in XYZ from X account, amount to be determined. Then, okay, at least I have an answer. And then, of course, by the time we get to trial, if trial becomes necessary and you haven't supplemented, then you're stuck with your original answer. So it would be your duty to supplement. And I get that.
Oh, yeah, you have a right to object if she doesn't, and that's how it works. No, I understand. No, and I think she does too. That's not an issue, right? So, and there was no objection either, so,
Right,
you
so
know,
21 and
it's up to
22.
her to answer it the best way she feels she can get it in at trial.
Okay.
Okay, 23.
So just,
I didn't
just-
understand this question.
Your Honor, just so we understood, 21 and 22 is granted to the point that she would provide a complete answer, correct?
Oh.
As opposed to the answer of, you may find the information in documents produced.
Yes, that is granted, the
Okay.
21 and 22.
23, I believe, I don't know, Ms. Maddox, were you going to remove the NA on that one?
Yes, I was going to remove that and put, we have not made that claim.
Okay, so we'll just say that one's agreed, so that one's off. 24. Uh, 24, Judge, again, the objection.
Oh, I told him that I would amend and withdraw my objections. Those are my notes on that.
So objection will be removed.
Yes.
Got it.
Okay. So we can move on to production.
There's 25. Oh, well, yeah, and 25.
Oh, we're dropping 25. Judge.
Yeah, I was gonna say that. I scratched it out too.
Yeah.
All right, so, all right, moving on to the request for production.
We're dropping one. And then number two and number three. Again, Judge, objecting at this point to these items. It is a list, but again,
Hold
we're
on.
entitled to.
I said I was withdrawing. The agreement was that I would withdraw my objections and provide Bates labels.
I'm sorry, I have on my notes that specifically on number two, we're going to the judge on the objection because you wanted to keep your objection.
I have on number 2, withdraw and provides Bates labels.
I had, and then number 3, you were gonna mail us a flash drive, so I was gonna drop 3.
Yes, that's right.
So 3 is dropped, 2 is agreed to put, okay.
4 and 5.
4, I was gonna amend to say, see attached tax returns.
I didn't have that. I had, we're going to the judge, so you now agree to remove your objection or to provide an actual response.
There's no objection on number 4.
I know, that's.
It says see attached, and I'm adding tax returns.
Let me correct myself. There was no objection. I stated there is not.
Okay, we got it. All right, it's okay, there's,
Right, and then my issue is just with some of these judges, like in this one, she says, see attached. Well, again, it's not my responsibility to go identify and see which attachment is responsive to his statement. So I had asked her.
let me ask this question because, I mean, everybody.
Actually,
Everybody responds differently. I mean, Yeah, Ms. Maddox, I mean, and I don't know that you're doing this, but you can't just get all your requests for production and say, here, this is responsive to.
No,
this."
I didn't do that. And
Okay.
that's what I'm about to say is what the rule says is that must either produce the discovery materials as they are kept in the usual course of business and organize them and label to correspond them to the categories of the request. So what I did was, it says or, and so what I did was when I produced them, I labeled them tax returns. I labeled it pay stub. They all have labels on them that correspond to the request for production. And so I have complied with the rules.
And that's kind of what I did, but I just, that's a suggestion. Okay, you all have an agreement on this, is that when I put a label that says tax returns, I identify which interrogatory or request for production that is relating to. And that's just an added step that I think helps avoid a lot of these motions but again, you have an agreement on this. I'm just throwing it out there. I'm not accusing you of doing it wrong, Ms. Maddox.
Well, and Judge, normally I would do that, but if you recall, I asked for 2 more days because my discovery was due on Monday and my child was sick all weekend long. And I asked for 2 more days and he refused. And so I complied with the rules as best as I could to get them to him timely.
Okay, I understand, Maddox, and it's not a criticism, and let's not get into that again. I remember that.
Well,
So,
Judge, if we're bringing it up, and you, if
Yeah.
you recall,
no,
we got our back up against the wall because the temporary order hearing was coming up, and we had nothing to be able to look at what
that's-
that outcome was, and that was a big push. Was
no
just
one's criticizing either one of you for zealously representing your clients. That's not, you're not gonna get that criticism from the court. So I just threw it out there as a suggestion. It's not a criticism. So let's move on to number 4 is going to be supplemented. Number 5,
Number 5, I was gonna write, see attached pay stubs and tax returns and withdraw the objections. And he said he wasn't, I think you only wanted, because all the other documents, remember, are attached to the tax returns or I don't have any. So I was just gonna withdraw the objection and say, see attached pay stubs and tax returns.
okay. And I have a note here that you wanted to go specifically to the judge, but if at this point you're changing that position, then that's fine.
I'm
Good.
not, I'm
Okay,
reading my
fine.
notes.
all right,
Sorry,
guys,
your notes are wrong.
agreed.
My notes are not
Yeah.
wrong.
Okay, guys, we're agreeing and you guys are just
I'll tell you what.
fighting over the agreements you have.
I'll tell you what, Judge, let's do it this way then. Rather than sit here and go back and forth, number 5, I believe the objections are inappropriate. We'd ask the court to make a ruling on whether the
Yep.
objection should stand or not, irrespective of any agreements, because at this point, there is none. There's no meetings of the mind, so Judge, we'd ask for a ruling on number 5.
Judge, and I previously agreed to withdraw my objections and amend my response to say, see attached pay stub and tax returns. That's the notes that are reflective of our conference the day before yesterday.
And once again, Judge, that's not mine, so that means there is no agreement. I'd ask for a ruling from the court if number 5 is granted.
Well, the court's going to order, as indicated, that the petitioner produce the documents as she's just stated. And I will tell you, Mr. Garcia, that
They were already produced.
hold on a second. Yeah, she's going to correctly label them. I don't know why you're going back to 2016, but I'm going to leave that as it is since they've already been produced. All right, let's move on to number 6.
So again, Judge, so does that mean number 5? And here's the big issue with that, Judge, is when I spoke to Ms. Maddox, she alluded to and did point me that items responsive to this were buried in a tax return attachment. And they were made part of that tax return, which is fine, but they were not identified. And once again, it is not my responsibility to go through every item and decipher what goes where.
Yeah, and if she takes my advice,
Judge,
she'll put number 4 and number 5 on the tax returns, and that'll answer the question, or That'll suffice for
That's-
production of these documents.
That's what I did. And because I only have the obligation to produce them as they are in the ordinary course. And so if the K1 is attached to the tax return and I produce it attached to the tax return, then I've complied with the rules. I don't have to separate the tax return and say, here's the K1. I can produce it because it's attached to the tax
Yeah,
return.
but you do have to identify that that is responsive to the different questions. That's-
Yes.
Oh.
And that's what I did. And that's what I'm agreeing to do.
If we're looking at the item, Judge, there's objections and then there's subject to objection, see attachment, otherwise there's none. See attachment. That does not give me.
I'm
the
gonna
right-
order that if the tax return was produced and the W-2s and or the 1099s, that you just clearly identify that that is responsive to the two different requests for productions, and it may be responsive to some others.
Now, I will state, Judge, when Ms. Maddox and I spoke, I did express to her that I recognized that she actually bait stamped everything. And that would have been a lot easier had she just identified in each step, in each production, see Bates item number 32, see Bates item number 15. And then at that point, there's no
I
doubt.
don't have to identify by Bates label, Judge. That's overly burdensome. I've produced them and labeled them accordingly.
Ms. Maddox, please listen to
They're
my.
labeled, I mean, that sufficed, but I see what you're saying, Mr. Garcia, that you can't just
I-
she
I
can
did-
either do it by labeling them or identifying the bait stamps. Either one is
Right.
Right. And I
worse
didn't
than the rules.
do it, I suggested, is what those were my words.
Well, I mean,
But
at this point in the game, I think, then let's just keep going. I'm not gonna add fuel to the fire. All right, number 6.
Judge, I may be wrong, but I thought that we had agreed that the time period was going to be 2019 to the present.
once again, there's no agreements. Obviously,
Well,
Okay.
No, there wasn't, but that was my input into this. Why are we going back to 2016, 17, and 18?
and again, Judge, I will state that Ms. Maddox and I did speak. I thought we had an agreement. Apparently, we didn't, which is the reason I'm now taking the position that there was no agreement. So
Well, I understand that, but you're both in the heat of battle. I expect both of you to be big enough that you're gonna have disagreements, that we don't start backtracking. So, since you did not have an agreement, then I've ordered her to correctly label what the production is in response to. But I'm also limiting production to 2019 forward. And that was for 4 and 5 and number 6.
actually, Judge, we are withdrawing 6 and 7.
Out.
And I did tell Ms. Maddox that I would have never made either of those requests.
Okay, what about number 8?
I believe we had an agreement that Ms. Maddox was going to remove her objections and supplement with 2019 and 2020.
And that's
But you,
actually the notes that
the
I
further
have.
agreement was that it was just going to be the bank statements, that he didn't need everything.
That is correct.
Okay,
So I'm going to remove the objection and provide full bank statements only for 2019 and 20.
all right, number 9.
Number 9, we're going to ask you for a ruling, Judge. That was one that we couldn't agree to. I don't believe the proper, as these are proper requests, given the property that's at hand and the potential for separate and community. So we'd ask that the objections be removed and a proper response be provided.
And I believe it's overly burdensome, harassing, overly broad, and unreasonable in scope, would cause unnecessary expense because it asks for all documents that relate to the value and character of all of the parties' property, whether it's in my client's possession or whether it's in his spouse's possession, which he couldn't possibly know, or possession of a third party. So now we're talking about third parties. And again, we're talking about every stick of property, which is just overly burdensome.
Yeah, I'm going to sustain this objection, but I think this one is possibly fall into our inventory revisit category. So for now, I'm sustaining the objection.
Okay, and then 10 is basically the same thing with debts. There's objection to that, and they don't feel that they need to produce anything in relation to debts.
Well, it says the party's debts. I don't have control over of what's in possession of Mrs. Alanis and her debts,
I
Judge.
don't think that's
And
what
so
the-
I can produce,
Okay,
Right,
go
but
ahead.
the objection's to the whole thing. So you're not, if you would have stated these are this is Mr. Alanis, we're not aware of Miss Alanis, that's fine, but you didn't do that. You just objected to the whole thing.
well, because I thought it was improper. And so I can supplement with but I want a ruling on my objection that I'm not obligated to produce everybody's debts, and especially the ones that
No.
I have no idea that are there.
No, you don't have to, but the rules do contemplate that you do answer to what you do have access to. So you could have put that in there. You do have to produce the debt in relation to Mr. Alanis.
And Judge, I would ask you to look at the response because I'm looking at it now and there's nothing in there about objecting to producing anything that is at the control of Alanis. It
I'm
just,
specifically overruling
Yes.
the portion as it relates to Mr. Alanis.
okay, so granted as,
As to Mr. Alanis only,
right. Okay. Number 11. I believe, correct me if I'm wrong, Ms. Maddox, you were going to remove your objection.
I'm going
and-
to withdraw the objection and stand by the response that there are none.
Correct. Okay. We're dropping 12. 14, 15. 14 and 15, I believe, Ms. Maddox, correct me if I'm wrong. You're going to withdraw the objection and then provide an answer, which I believe is going to be
And
no.
put none. Correct.
Okay. 17. 17, I believe you were agreed to try to obtain the deed of trust from property records and web.
Correct.
18.
deed of trust, okay.
18, we just agreed she was going to supplement as best they could.
Yeah, but
Yes.
I put a question mark. I said, what, no cars? And again, this is gonna fall into the inventory
Right.
category.
And then we agreed that I was going to drop 19, 21, 22, and 23.
Dropped.
25 too, right?
22 is being dropped?
All the way through 23.
And I believe you were going to drop 25 too.
24 is dropped as well, Judge.
And 25 is dropped.
And that's fine. 25 is. I don't have that in my notes, but that's fine. 26.
We agreed that we would supplement, Judge, for the years
18, 19, and 20.
18, 19, and 20.
Just want to remind the parties that we may have some visitors coming in. Their attorneys, not defendants. The district attorney's office and public defender's office may be appearing shortly.
Yes,
If
sir.
that happens, we'll break for those 10 or 15 minutes and then finish off.
We're
Well-
almost done. We're very close, Judge.
Yeah. Okay, so 26, we're gonna amend 18, 19, and 20, so 27.
Actually, Judge, we skip all the way to 34.
So
Or,
So-
right? Hold on. I'm sorry.
30, that's right.
I have 27, 32, 33, and then 34.
Okay, 27, 32, 33, those three. Again, that she saw the C attached. Ms. Benavides, if you could just either identify by tab or by Bates number, that would take care of 27,
Oh, I
30.
thought that you were omitting those. Okay,
I mean, they're an easy fix unless you object to that.
yeah, I'll do that. That's fine. And then, but that was what? 27, 32, and what? 33?
Yes, ma'am.
Okay. And then 34, I said I would remove the objection and answer none.
Correct. 36.
We
36.
agreed that I would provide the last 2 years.
Correct. And then I was
And
going
then
to
we also agreed
do the same.
that she would also. Mhm.
Correct.
Her too. Got it.
37.
37, I'll remove my objections and stand by none.
Correct.
And 44, I think you were gonna omit, and I think we're done.
Yeah, we're dropping 40.
Okay.
And then argument on attorney's fees, Judge, if I could present.
Uh,
I'm just kidding.
You have older brothers, Mr. Garcia?
I do have an older brother, Judge.
You have to fight for everything in your house? Is that why you're so?
Yes,
So,
I did.
I had an older brother too, so.
Yes,
Look.
mine was 3.5 years older than me. I was a little scrawny kid and he actually was a big dude. And now he's a cop. And so I had to take vengeance, so I became an attorney.
Tony, look, we've gone through this, Mr. Garza. I'm going to deny your attorney's fees and just remind you that I remember the court being lenient right around Christmas, and I'm glad to see that you fully recovered from your COVID based on the motions, all the motions I had to go through in this case. But I will just make an announcement to both sides that I think a lot of this could have been resolved without the court's time. The court is not opposed to, in the future, to taking a more active role in punishing the transgressors, okay? So I'm denying any attorney's fees at this point in time. Make sure I get a copy of those dates, and I guess we can interact as to which dates are going to be proper. I'm going to take a look at what we have by way of inventories in our local rules and see if they need to be tailor-made for you for this case. See if there's anything else so that what we'll do is we'll start the 45 days from the date I guess I send you the inventory. But there's no reason why.
Judge, I have the form from the Texas Family Law Practice Manual. That's the one I usually use. It's very extensive. I will mail that to you and email it to you and to Mr. Garza, just to make it easy on the court and see if you agree with that or if you'd like to use a different form.
Sure. I mean, I'm open to anything. I mean, it's been years since I did a divorce where we had to do that extensive an inventory. I'm sure I have one in my old files, but that would be helpful. So go ahead and send that in. I think, yeah, my trial docket or my docket for the rest of the week is fairly light in the afternoon, so I will be working on this case so that we can make some progress. I think we did today. So I'll let you go. I've got pretrial services here, so I'm going to start another docket. Guys, thank you. Yeah, I'll leave you with Rodney King's words. Can't we all get along? We'll go from there. So see you all later.
Thank you, Judge.
Thank you.
Thank you.
Everyone's
Be safe.
excused. Yes,
Thank you, Judge.
okay. Just a minute, Mr. Villarreal. I just finished another document. There's people signing out, so we can get started. Are we expecting the district attorney's office?
I'm not sure. I don't think so.
You have the criminal history, Judge,
Yes, I do.
and the list as well?
And the list.
Judge, may I
Yes.
have,
Oh, Miss Nino,
may I have 20 seconds?
you can have all the time you want. This doesn't have to be recorded. So, yeah, no, you're fine. This is an informal hearing we do on a weekly basis, so you're not interfering with us. Hi again. So,
Just need a quick break. Thank you.
okay. Omar, I missed you from morning magistration last 2 weeks.
Yeah, I was having like other hearings, and then I called Jesus, and he told me, oh, because I didn't receive that list either, and he told me like he was super busy and all that.
All right, hold on. Can you share this stuff?
Mixed up.
All right. All right, let me reorient myself here. Wait, did you get a chance? I forget the name of the defendant whose name I gave you, who was in there for 2 misdemeanors and said he'd been there for a while.
Yes, I got a PR bond for him,
Oh, good, good.
Judge Leticia. I don't remember the name, but I remember he was released.
Yeah, I mean, he had some history, but I didn't think it was too excessive, and he'd been there for a while, and I just thought, well, okay, I'm glad, thank you. The court appreciates that.
Yeah.
Oh, my God. Oh. All right, so let's start off with Mr. Well, it's 3 o'clock and the district attorney's office is elected not to appear again. I just, so you know, well, I don't know if I need to. Yeah, this is an administrative hearing and we're on live on YouTube right now.
Do you need a record, Judge?
Not of this, no. There's no evidence being presented. We're just going over some procedural issues. Let me